how would you say did Michael influence or inform the work of CCR in relation to corporate accountability? What do you think was his political analysis of the importance of this work?
Thank you, and I really want to thank ECCHR for having me here, Wolfgang, Claire, and Miriam, and Claudia. And I'm happy to be talking about corporate accountability, and Michael and Peter. My first time at ECCHR was actually 2008, when you had your, I think, first large conference, which was on business and human rights. And I think the fact that that conference was on business and human rights, that all of you, with Peter and Michael's thoughts and Wolfgang's and Miriam's vision, understood the role that corporations have and the very powerful influence they are on both the protection of and the abuse of rights. And that trip, to be here with the two of them, and particularly to be in Berlin with Peter Weiss, was a very, very special experience. But we at CCR had actually been doing corporate cases even before the ATS, the Alien Tort Statute, and Jules mentioned Palestine. And one of our first cases around Palestine was actually a corporate case. It was during the first Intifada, and it was around the selling of tear gas from Pennsylvania to the Israeli Offensive Forces, the IOF or IDF as others may call it, and seeing that the US was playing a role in really oppressing the uprising against the occupation. So that was an early piece of Michael's involvement and Jules' involvement in corporate work. And then when we had the Alien Tort Statute and the Kadic v. Karadzic case, a case against Radovan Karadzic, who people may recall, the self-proclaimed president of the Republika Srpska, he was brought to, he was a defendant in a case under the Alien Tort Statute. And that case set the precedent for recognizing non-state actors could be held liable for corporate violations. And with that, in the mid-90s came the corporate cases. And one of my first involvements with Michael was around the Caterpillar case, which was a case where the US government was subsidizing the sale of Caterpillar bulldozers to Israel, which were being used in house demolitions. And in the process, not only destroying homes in the occupied Palestinian territory, but also injuring and killing people, including Rachel Corrie, a US human rights activist. And in that case, what was interesting how it was put together, and I credit my colleague Maria LaHood, who's not here, in this also, working with Palestinian human rights organizations, seeing that there needed to be not only a US victim, but Palestinian victims. So it was using the challenge to corporate power to also build a movement and solidarity. But the cases that I very much was involved with Michael, and I think this speaks to kind of how he saw corporate power, was the cases against private military contractors. And when I was here at the conference, Miriam asked me to speak about cases against trade unionists and the labor movement. And we had recently filed at CCR a case against Blackwater, the private military contractor. And we had already been litigating for a number of years cases against Khaki and Titan, which later became L3, two private military contractors that were providing interrogation and interpretation services at Abu Ghraib. And they were identified in military reports as having been complicit in torture. And Michael was critical in formulating those cases in 2004 and was extremely engaged in bringing the Blackwater case and motivated to do that. And why? Because he saw the issue of corporate capture in a way that I think we are only catching up with now in the rest of the world. You know, as someone who is anti-war, anti-imperialistic, you look at the root causes of why we go to war. And so often we go to war for profit. It may be natural resources, but there are corporate interests. And the war in Iraq, a critical piece was the private military contractor business and all the business that came from that war. So to expose the profit motive and the role of private power, corporate power in furthering abuses, and going in, the Blackwater shooters had such an air of impunity. The corporate power of in an environment of occupation was incredible. So I think he saw the move into challenging corporations as challenging a root cause of conflict. I think he saw it as exposing the relationship of the state and the financial interests and the elites in furthering war. And, through that, we've now have a very vibrant corporate accountability movement globally.
We have just seen in the video Peter talking about the Kiobel decision. And as you remember, it was a bit of a shock when it came out for not only the people in the United States, but also for all the people from this movement that you mentioned outside, because since then, until then, we always thought, well, we could at least go to the United States as a forum. Now that door seems maybe closed, maybe not. Peter says, well, it depends on who defines what needs to be defined. What do you think? How did this decision change your approach to corporate litigation against corporations in the US? Would you think that now maybe this opens up the way to use other fora, for example?
Yeah, I'm going to give a slightly long answer again, Claudia, if that's okay. I was actually at an ECCHR conference in Colombia with you and with Wolfgang in 2010 when the first Kiobel decision came down, the Second Circuit decision, and that decision found that corporations couldn't be held liable for international law violations. And I was supposed to be speaking about the Alien Tort Statute, and literally from one day to the next, I didn't know what I was going to speak about because we had this horrific decision that said you can't sue corporations. So I think it's important to remember that Kiobel actually went to the Supreme Court the first time on whether corporations could be held liable under international law. And the Supreme Court pivoted on its own to the question of extraterritoriality. And I think for us as lawyers who are challenging corporate power, the fact that they ducked that question, in fact, affirmed the fact that you can hold corporations liable. The US Supreme Court was looking to limit the Alien Tort Statute. It was looking to knock the legs out of the growing corporate accountability movement. And what we had seen happening in the US of suing companies, we were seeing happen increasingly in Europe. We were seeing happen in South America. We have huge victories now in Argentina taking on corporations. So the Supreme Court was reacting to really a movement of global accountability. And of course, yes, in 2013, the decision came down saying that only those cases that, quote, touch and concern the United States with sufficient force could be held, could be brought forward in US courts. And you would think that that would mean a US company. If you look at the traditional bases of jurisdiction, and as you have in the European Union, the home country should always be a forum for a company. Unfortunately, we haven't seen that be the rule across the board in the US since 2013. The cases are still bubbling up. We have had success at CCR, Jules, in a number of these contractor cases, both before and after Kiobel, because these are U.S. companies. In 2014, my colleague, who will speak on the next panel, Bahar Azmi, argued our case Al-Shamari v. Kaki, where we pointed out that this is a U.S. company, literally headquartered down the road from the court, that was operating in a U.S.-run detention facility in U.S.-occupied Iraq, where U.S. corporate employees were working with U.S. military, who were later court-martialed by the United States military, and carrying out some of their activities in the United States. So a case like that, with all of those connections, has been able to proceed. Cases with fewer connections, even those against U.S. corporations, have not had as much success. So we are seeing fewer cases filed, but we are also seeing people look elsewhere. That could mean that we're using different laws and challenging maybe some labor practices. People are looking to go into state court. People are looking at other countries. You know, again, we have a movement, and now we have opportunities elsewhere, and we may have the boomerang coming back as before it went out. And we're also following what's happening at the international level. The fact that there are proceedings in Geneva about a possible binding treaty on corporations, we see as a very positive step. Whether we get that treaty is almost beside the point, because there is such a mobilized civil society and that global corporate accountability movement, which frankly is being led by civil society and activists in impacted communities from the global south. There is no way that we can kind of turn back and say, all right, you corporations, you're going to be able to get away with this.
Okay, thank you. Turn to Miriam now for a while. The title of this panel, as you've seen on the program, speaks about fighting corporations. So when we talk to some of our partner organizations in the South, they would probably frame the issue differently. They would say, well, we are defending territory, we are defending environment, we are defending indigenous rights, for example. So they would say we fight for something rather than against. Now, of course, for us, we've always seen that being far away from where things happen on the ground, working transnationally, for us, maybe we have a different kind of look at things. We have a different political agenda, probably, about the cases. Would you then say fighting corporations really captures what we do?
Well, I think to some extent, obviously, in the concrete case, it does, because we are fighting against the practice of a certain corporation. And I think also that a lot of the times, the legal arguments that we have to use are narrowing us also quite down to challenging and being quite defensive about and just challenging the most extreme actions of companies, right? And the most extreme effects that companies have on the ground and for the people affected. So that means a lot of times we do have to challenge the massacre, we do have to challenge the catastrophe, factory catastrophe, and we cannot challenge the daily practice of exploitation and you know, the ongoing forceful but a little bit subtle displacements of people when mining companies are just polluting a whole Andean region, right? But at the same time, I would also think, and in the broader picture, obviously, it's not just that we are fighting this one corporation on this one action that may be litigable, but that we are actually fighting for a different and more democratic and more just world economy, if you want to put it on the very broad level, because we are challenging corporate power and we're saying it must be done differently. And then I think obviously there's this large divide between the concrete case and the one aspect that you'd litigate, and then this broad vision of challenging world economy, and then the question is, how do you connect those two, and how does the one thing contribute to the other? I think that's obviously a very philosophical question, and a lot of times quite challenging. But I definitely think we shouldn't forget why we bring this concrete case. And I think something that I heard this morning was, and I think that's also something that I learned from Michael, is to ask, what is my responsibility and why am I bringing such a case? And I think, why is it important to bring cases against from our perspective, European companies? Well, because I think it is our responsibility to also fight those practices that come from Europe, that we all benefit from as consumers. And sort of, so this is why I would also say, while fighting is probably a little bit too much of a narrow term, I would still think that is quite useful, and that is something that we have to do, bearing in mind that I think the overall goal is much wider and much larger. And that obviously it's also a lot about not just fighting a corporation, but also being in solidarity with the local movement. What I find difficult to say from a European perspective, it's, it's not necessarily my personal struggle on the ground in the Andes for the right of to water. And I'd also feel like, I think it's important to be a little bit aware of that there's a difference between me sitting here and bringing a case and the local movement, but I do want to be in solidarity and put my work into contributing and benefiting them.
Okay. Now, the other part of the title of this panel speaks about transnational collaborative lawyering. It's a long expression. I wanted to ask you, in your opinion, what is particular about transnational collaborative lawyering? What is particularly interesting, particularly challenging? Where do you think its particular potential? I don't know. Maybe you can cite cases where you can illustrate it. If that would be nice.
Well, also this morning we heard a lot about the movement lawyering and the importance of the connection between the cases, the lawyering, and the social movement that is actually also making the case, turning the case into a success, whether in court or out of court. And if you think about that in a transnational aspect, obviously the connection to the movement on the ground and is much more difficult to organize and to establish. So I think the big danger is that it's us sitting here in Berlin or in Paris or somewhere and litigating a case and being very far removed from the people on the ground, really, and being very far removed in our legal arguments and how we're going to deal with this case. And the question is, what will be the impact then back to the community? Because obviously those cases, since they are limited, it's very rarely that we will ever, do away with the whole mine, right? We may trouble in some aspect, but so I think that's a big danger. I think we've, to be honest, I think we've seen cases where I would say especially criminal cases. I'm not sure that about the impact of the Nestle case, for example. We filed a criminal complaint against Nestle headquarters and their managers, alleging that they have been contributing to the murder of a trade union leader, Luciano Romero, in Colombia, and that they have not done enough to prevent his murder. I think this case has been very successful. We didn't win it, of course. But it's been very successful in Europe to stir the debate. It had a serious impact on how also on how the whole Swiss civil society, but also politics, talk about corporate cases. And I think, but the impact for the Colombians has not been that much, and it has been much more disappointing for them, for the union that Luciano Romero was part of, as well as for the wife and his wife. So I think that is challenging, and we've got to be quite honest about it. No, I don't want to end on such a. I think there's still potential in this, and where the potential is one case that I've been working on for the last 3 years is the case of Pakistani workers and family members of deceased workers against a German retailer. So they have been filing the first civil litigation lawsuit in Germany of this transnational kind against the German retailer. And here you can see that the potential is that it did empower the victims, it did empower those affected, and this case is empowering also the union that is working with those affected. And I think this has been quite extraordinary how it was been possible for there was a fire in 2012, 260 people died because they simply couldn't escape the factory. All the workers were scattered, they were not unionized. The family members obviously hardly knew of each other. And over the last 4 years, with the help of this union and their tremendous efforts, they have been building a victims group that has its own political agenda. They are litigating several cases with Pakistani lawyers in Pakistani courts against government officials, against the factory owners in Pakistan, asking for pensions and so on and so on. So they have but not only, but they also have a political agenda. So they are going to other factories. They're trying to educate workers. They're trying to, mobilize also and work on politics, on that Pakistani labor laws need to be changed and so on. But they also decided that with us in several discussions, Caroline and I have been in Pakistan 6 times since then, to discuss, and they also want to address the international angle. But they do understand it, that is something that matters to them, because it is the international companies that come into their country that give them employment, but they don't want to let them go off their responsibilities. And I think this has been quite impressive also to see how they can really use what we are doing here, so that they understand, and that they are not, and I think also for them, we've always been discussing that, they are not dependent on whether we will win or lose this case. They know it's really not about that. They understand that this is about also political effort, and that, so it's not that, they know exactly why they do this, and I feel very comfortable. And I think it's amazing to see this group of people, a lot of women that also speak up in larger meetings, which is not usual for Pakistan, and to see how they really deal with this case, how they think about it, and how they're very aware of the the advantages, but also the downfalls of such a case, and that it will not recover all their hopes. It's been helping the union, also to talk about empowerment, it's been helping the union to be more respected as an actor in Pakistani politics that needs to be consulted. So this union has started to be consulted by the ILO, which they have not been before because they are very radical, very on the radical left. But it did give them sort of the weight of, because it shows that they are able to have international alliances and that they are able to have international corporations, which other unions may not have, in combination with their ability to really organize people and to form a group that is meaningful and is able to find consensus and is able to find their own political agenda. So, and if you see such an example, this is obviously very, very inspiring. And to see, and I think that shows the potential, but again, I think it depends on many aspects of if we are able to create this. And it surely doesn't depend only on us lawyers. There's so many other factors around it.
Okay. Now I would like to go a little bit more into what lawyers would probably consider the juicy bits of this discussion, which is more the legal technicality questions. Katie, when you look now, making use of the fact that we are here coming from civil law traditions, from the common law tradition, and being able to exchange our experiences, when you look from all what you've heard of the civil law tradition, as you're coming from the common law tradition, are there things that you are envious about? Are there things you would say they work in the civil law tradition and we have nothing comparable in our law tradition? For example, I see that in the common law tradition there's very few criminal cases brought against corporations.
Yeah, and I'm a sort of bad common law lawyer because I spent my first 6 years working in Europe and primarily working with civil law lawyers. So I can't quite get what some of the advantages are out of my head and forget that we can't do that in the US. But yes, indeed, starting with the last point, can we bring a criminal action against a corporation? We can't in a common law system. You're able to have plaintiffs start the cases before a prosecutor or an investigating magistrate. And for us, that is part of why the Alien Tort Statute has been such a valuable tool. It has been a vehicle for victims to frame their case, to frame their claim, and to move it forward. I mentioned the contractor case on behalf of Abu Ghraib. We have not seen prosecutions of the contractor, either the company or the individuals who were involved. And in the early years of these cases, there were overtures made from the legal team to make victims available, to make information available to the Department of Justice. And during the Bush administration, that was not something they were particularly interested in, nor has there been any open investigations during the 8 years of the Obama administration. So yes, I am envious on the one hand of the ability to bring criminal cases, but I think we're still able to get pretty far with corporations in the civil context because at the end of the day, the profit motive is what drives them, and a civil action where you can get damages that impacts their bottom line. So I think we're able to get a certain distance, but I can tell you from the individuals we represent, they would also like to see criminal proceedings. And that's where the work of corporate accountability also overlaps with the universal jurisdiction work. And so when we hit up against a wall in one way, maybe we look to you, and that's where the transnational legal community is so important. Because we're not only looking at one venue or one body of law, and we can go elsewhere and pursue a case. But in the US, we are able to bring cases where if we lose, we do not have to pay the massive fees that some lawyers do in other countries. So we're able to bring a case without that. They're expensive to bring, I shouldn't deny that, but we are at least not penalized if we lose. And we have more generous discovery laws so that if we make it past the motion to dismiss, we can get information about how our corporation works and about the violations. And that I believe our laws, our discovery laws are much more generous than in Europe. So I think there are advantages and disadvantages, and this is where having that global movement so that we can take what works best in one venue and maybe then we bring it to another to move the case in another direction.
Okay, thanks. Miriam, so it's about the same question to you. What are you envious about the common law, in the common law tradition? For example, Katie was mentioning the discovery laws. Do you think that might, and how would that maybe influence your casework? There's little civil cases that you bring. Why is that?
Yeah, I think obviously it's first thing that pops to your mind is the discovery part, which discovery rules are very narrow in Europe, if not non-existent almost. So obviously that makes civil litigation much more viable in the US, but I think it's actually even from the technicalities way, something else. I think the advantage of common law, the common law world, is that it allows for much more creativity on how you want to use the law. There's more flexibility in using precedents than if you have to stick with the code that you're dealing with. Plus, I think it also has something to do with how your legal education works. So that I find common law lawyers oftentimes a little bit more creative and open-minded than people from civil law countries. So and then I think in general, I think we have to say those cases are, by now I would say it doesn't matter which jurisdiction you go to, they're always challenging, and as I think Jules Labelle said this morning or before, those cases are won on the facts, and I think then, and they are only won if sort of the political environment wants those cases, and I think so. But I actually think, we can talk about this jurisdiction has this advantage or that advantage, and this law is better or not. But what I find more and more is, I think the question is, what is the general opinion of the public where the forum is? What do they believe is the power of corporations in our case? Do they actually, how sympathetic are they towards them? Because most of the times you have this reaction of judges or prosecutors that are like, oh, well, but this gentleman from this business world, how can he possibly know that women get regularly raped in the DRC? He can't, and then he's like, yeah, he does, because he's there regularly, and he's, so I think actually what I also come more and more to, I think we've got to so much work on the political debate we have and on the perceptions of how we think those corporations work and how global economy works, and that it's not so clean as we all want to see. It's not white-collared. So I think that's sort of, I think, also a big part of our struggle is that we actually need to deal with how do we think those things work and what is criminal in this and what is not, even more, because I think everything has all legal systems have their advantages and their disadvantages. Because I think if you think about this retailer case of ours, I think every US lawyer would get a heart attack how bad we are or how little we know about the company. And still it's been accepted by the court because the judges also know, well, there's no discovery, so here those are the facts they have. You know what I mean? So I think the thresholds, obviously the more discovery of facts you need to bring is also higher. So, but obviously, I think civil litigation, it's an incredible inspiration, and I think for the whole global movement of corporate accountability work have been those US ATS cases.
Can I just add on, because you mentioned the judges, and it's certainly a challenge for us in the U.S. because you're assigned to a judge and you're then left with that judge's impression of your case that you're always trying to fight back on. And we brought the Blackwater case before a judge who was appointed by Ronald Reagan. And we were charging Blackwater with war crimes and torture, and we had beautiful arguments in our briefs about Nuremberg and, the international law recognizing war crimes. And our judge said to us, I don't want to hear about Nuremberg, it's victor's justice. And so, okay, we're not going to talk about international law. We talked about the fact that we have a War Crimes Act. But this older judge then started asking a lot of questions about how Blackwater as a company and how contracting worked. And then he went on a riff about how when I was in the military, we worked in the kitchen. We were responsible for doing the electricity at our bases. And he was so disturbed by how much outsourcing was being done that we connected with him not on a legal level, but on a kind of deep structural level, that he was so uncomfortable with what had happened with the U.S. military post-draft and as we went to war for profit. And ultimately, he allowed the case to proceed. In our torture cases, we initially did okay with the idea of torture because at that point there was a lot more sympathy for Abu Ghraib. When we talk about Abu Ghraib now, when I go out and talk at schools, it's shocking how many people have never heard of Abu Ghraib. And again, we just had a very good victory, and I credit again Bahar Azmi over there, where we had a Court of Appeals decision come down as firmly as any court has come down yet, saying that torture can never be a policy of a president, and it critiqued subordinate lawyers, redrafting laws to try and make torture lawful. And the judges reasserted their role in saying, no, torture is illegal, you can't do it, you can be held accountable. And wondering why this decision came out in 2016, 12 years after the Abu Ghraib revelations, we haven't seen accountability for torture by the Department of Justice. We've seen President Obama acknowledge that, quote, we tortured some folks and no investigations have happened. And then you think of the Republican primaries, where each candidate was saying, no, I'm going to torture even more than you. Waterboarding is not enough. And so we have the public that we try and mobilize, but our judges are not living in a vacuum either. And whether it is a fear of how far you go when you move beyond what is lawful, this win that we got just 2 weeks ago, reasserting torture is always unlawful, I think has something to do with where we are as a country in 2016 on the eve of an election.
Thank you very much.